methods to determine the notional income for a homemaker. Some of these methods were highlighted by a division bench. That was all mentioned. Then 50% was also looked into. We need not go into this. 40. Paragraph 40. When it comes to the second category of cases relating to notional income for non-earning victims, it is my opinion that the above principles, type of profession, whatever, applies with equal vigor, particularly with respect to homemakers. Once notional income is determined, the effects of inflation would equally apply. Further, no one would ever say that the improvements in skills, no one knows what kind of skill is present. If we consider in the parlance of the matter that we are dealing with, right? With skills that come with experience do not take place in the domain of work within the household. It's worth noting that, although not extensively discussed, this court has been granting future prospects even in cases pertaining to notional income, as has been highlighted by my learned brother. I mean, this is Justice Suryakant. In his opinion, versus Oriental Insurance Company, Sunita Tokas versus New India Insurance Company Limited. Therefore, on the basis of the above, certain general observations can be made regarding the issue of calculation of notional income for homemakers and the grant of future prospect with respect to them for the purposes of grant of compensation, which can be summarized as follows. These are generalized without any specification. Grant of compensation on a pecuniary basis with respect to a homemaker is a settled proposition of law. Taking into account the gendered nature of housework, with an overwhelming percentage of women being engaged in the same as compared to men, the fixing of notional income of a homemaker attains special significance. It becomes a recognition of the work, labor, and sacrifices of homemakers and a reflection of changing attitudes. It is also in furtherance of our nation's international law obligations and our constitutional vision of social equality and ensuring dignity to all. Various methods can be employed by the court to fix the notional income of a homemaker depending on the facts and circumstances of the case. This court should ensure while choosing, the court should ensure while choosing the method and fixing the notional income that the same is just and in the facts and circumstances of the particular case, neither assessing the compensation too conservatively nor too liberally. The granting of future prospects on the notional income calculated in such cases is a component of just compensation.
May I, Milord? Milord, then what it did, Milord Kirti, if I ask this question to myself, Kirti said that I have taken note of Arun Kumar. I have taken note that this is not a rational basis of Arun Kumar's, Milord, this reflection of 1/3. Milord, this paragraph is there.
That is your interpretation.
Milord, the line is there. Milord, the line, the paragraph, Milord,
Sir.
Yes, Milord, yes. It did.
That's what I'm asking you.
Milord, it did.
There is no rational to it.
Milord, I'm grateful to your lordship.
Rationality curved out.
Yes.
Where?
Milord, it considered the Milord, in the computation, what amount it granted to the woman, Milord, to that lady, who was deceased. Kirti took, Milord, the minimum, Milord, this monthly wages, page.
Sir, said Delhi High
But it took into consideration. Para 11, your lordship will kindly say, Milord, it is there.
Husband minimum wages 619.
দাঁড়ান, চারটা করা আছে তো এখানে।
নিচে আমি দেখাচ্ছি তো মিনিমাম ওয়েজেস 6197
আচ্ছা।
আছে এই দেখো 6197 বউয়ের ইনকাম 55
Para 14, Milord।
ইনকাম অ্যাসেস করেছে 6197
আরে হ্যাঁ, দাঁড়াও না প্যারা।
মিনিমাম ওয়েজেস তারপরে চার্ট এখানে para 14 619
Para 14, Milord, your lordship kindly have a look at the chart. It discarded, Milord, Arun Kumar. My lord is kind enough, Milord, to come to the chart, Milord. Milord, the tribunal, Milord, husband and wife both died. Milord, what tribunal did? Milord, it took, Milord, the figures are there, and Milord, the last column is Supreme Court. It took.
These are all the contentions of the parties addition.
No, this is the computation made by the Supreme Court. Supreme Court has said the income.
Sir, deduction on personal expenses, assessment of monthly.
Is my lord there in the chart, Milord?
Yes.
The very last column, Milord, the Supreme Court, Poonam. Poonam is the deceased wife. The very first, Milord, column is A, monthly income, 5547.1. This is the monthly income considered by the Supreme Court on the basis of minimum wages.
हस्बैंड इनकम ये कहाँ से है पैराग्राफ 11
Husband की
तो
जरूरत
वन
नहीं
थर्ड
है।
नहीं हुआ है उसका
Milord, husband's income was 6197, 6197. Milord, this is not 1/3 of husband's income, 5547. The just and rational Supreme Court said that no, we will not take note of Milord Arun Kumar, or we will not follow Arun Kumar. Husband's income was taken to 6194, minimum wages of Haryana government. Wife's or the Milord, the lady's income was taken as 5547.1, not followed Arun Kumar because it is not rational.
has followed Arun Kumar because Arun Kumar says to follow the guidelines of Lata Vatbha.
And Milord, I'll go a step further. Arun
Has followed Arun Kumar.
Milord, till date, I can assure your lordship, Milord, may I? आप तो रुको ना तुम, थोड़ा आस्ते, एक्साइटेड मत हो, आस्ते रहो, हर समय घर नहीं है, रुक जाओ, रिलैक्स रहो. Milord, I'll try to save Milord a little trouble of your lordship, Milord. May I? Hmm? Hmm. Milord, may I, Milord, at no. Milord, I can assure your lordship, Milord, till date, there is not even one Supreme Court which follows the aforesaid principle of Arun Kumar, wherein, Milord, the housewives or Milord, the homemaker's income is to be considered as 1/3 of the income of Milord, the spouse. Milord, Milord, this is Milord, first of all. Arun Kumar itself, Milord, While, my lord, forget about, my lord, this, my lord, what my lord has pointed out, my lord, is not considered to be rational. My lord, first and foremost is it should be just and equitable. My lord, the claimant in Arun Kumar's case, my lord, the homemaker or the housewife, my lord, it was asserted in evidence that she was earning rupees 50,000, 50, paragraph 37, my lord has gone into that. Paragraph 37. She was earning rupees 50,000 rupees per annum. Perhaps my lord has taken note of that.
Yes.
So, my lord, when the homemaker was earning 50,000 rupees per annum, my lord, there, my lord, Supreme Court, my lord, what it did, it said that instead of 50,000, I'll take it to 60,000 because of, in addition to what she was earning, my lord, I'll give her 10,000 rupees extra. That was the idea. So 50,000, which was claimed, which was asserted in evidence, was taken to 60,000. And that is how, my lord, it came down. My lord, I am referring, my lord, with regard to the just compensation. My lord, amount is 5,000, your lordship will kindly consider. It is only, my lord, 5,005,000, my lord. I would never be disputing, my lord, an amount of 3,000, 4,000, 5,000, 6,000. But only, my lord, when it comes to, my lord, an astronomical and absurd sum, my lord, then, my lord, the dispute arises and the question arises whether it is just, whether it is reasonable, a person who admittedly does not earn anything, whether his or her income can be taken to be 30,000 per month on the basis of the income of his spouse. My lord, this is where I join issues. This is where Supreme Court,
No, paragraph 37 is somewhat different.
my lord, 37, your lordship, I'll read the first sentence.
However, there was a shift in jurisprudence.
My lord, reverting to the facts of, my lord, it starts from that, paragraph 37. Arun Kumar, my lord is on Arun Kumar.
No, I'm on Kirti.
My lord, I'm not on Kirti. My lord, Kirti, my lord, I have shown to your lordship. Kirti referred to Arun Kumar and he did not follow Arun Kumar. It went into Minimum Wages Act. And, my lord, it also said, my lord, as has rightly fallen from your lordship, my lord, that the principle is, my lord, not taken into note of, my lord. Principle of Kirti. And however, rationale behind the ratio as 1/3 is not very clear. This is what Kirti has said. And after noting this, Kirti followed paragraph 11 and 14, my lord, the Minimum Wages Act. It did not follow Arun Kumar. My lord, now I go back to Arun Kumar. My lord, lordship, be kindly rest assured. Arun Kumar has not been followed in any other judgment as far as 1/3 part is concerned. If, my lord, income is 4,000, 5,000, 6,000, nobody in the world is disputing that. But the moment,
It must be
lordship,
right, sir.
my lord, it has to be just. Your lordship is this.
That is something
Yes,
we need to consider.
my lord, my lord.
It has to be just.
It has to be just. So that is why, my lord, I say, my lord, that is why, my lord, I humbly submit before your lordship, when a person who was not having any income, then, my lord, his income or her income cannot be treated to be 30,000, 40,000 rupees per month because of the spouse was earning more. This is where, my lord, I was trying to point out to your lordship. And this is nowhere has been followed. My lord, Arun Kumar, I go back to Arun Kumar because, my lord, the genesis is Arun Kumar. My lord, in Arun Kumar, if my lord is kind enough, my lord, may I invite your lordship?
Two word most important है reasonable and guidance. Reasonable important. Secondly, income कितना है 15416 डिवाइड बाय 3 करने से 5000 नहीं आता है तो ये भी नहीं फॉलो है ना 15000 कहाँ ये नहीं आएगा 5000.
This is one straight judgment on a particular principle wherein, my lord, reasonableness was more important, and that reasonable arose because of monthly income of a house or homemaker can be taken to be 5,000 rupees. Nobody is disputing that. But once you take that income 5,000 to 50,000, then, my lord, the difficulty arises because that is neither reasonable, that is nor just.
It has not taken guidance from Latavad. It is.
My lord, I'll indicate your lordship, my lord, further in my lord Arun Kumar. Why, my lord, the Honorable Supreme Court, my lord, in spite of saying that there is no rationale, it accepted 5,000. My lord, 5,000 I will not dispute, I will never dispute. My lord, it says that you take the guidance from Lata Vadhova. Your lordship has read that particular paragraph 36. Lata Vadhova, my lord, your lordship kindly sees, my lord, it has been referred to in this very judgment at paragraph 28. Lata Vadhava, my lord, the maximum income, my lord, of a homemaker was rupees 36,000 per annum. Arun Kumar is correct as far as the quantum part is concerned, not on the principal part. My lord, this principle was taken, my lord, from the second schedule.
Here they have taken 3,000 per month.
Milord, Lata Vadhava, my lord is the 20. Yes, that's what I say, Milord. So we are not disputing on the quantum part. Milord, the principle is, Milord, putting us into difficulty. Milord, this principle was taken, Milord, from this schedule, Milord.
Sir,
Lordship, Lordship.
there has been a way. Now, if you come to the later part, what about the scale? What about the, now see, the rationale behind awarding fee is therefore no longer merely about type of profession, whether permanent or otherwise, although percentage awarded is still dependent on the same. The awarding of future prospect is now a part of the duty.
Yes, that is true. So many things, I accept that.
That being the situation,
Milord, my lord is, Milord,
sir,
Lordship. My lord. Milord, your lordship will kindly give one thing in my lord is deciding just compensation. Lordship, kindly. Milord. Whether in the facts of
now if
Lordship, Lordship.
have to take everything into consideration.
I'm grateful to your lordship. Extremely grateful to your lordship.
Now, you have to see the societal status also, right? A person earning 50,000 and a person earning 5,000, basic difference must be there in the,
Way of living.
way of living, right? Now, if you come to a constant with regard to the income of the victim, here they have taken so many things into account. Now, you take everything into account.
I take that. Milord.
Then you
Yes.
say that, okay, fine, only 3,000. Or for that matter, 5,000.
Lordship.
If the deceased husband's income was, say, 1 lakh rupees.
Lordship.
per-
Lordship.
Right? And then you say that the wife's monthly income will be just if it is 5,000. It cannot be, sir. So I would rather go by the last paragraph of Kirti.
Lordship.
That is why I read it to you.
Yes, just. Just in the facts and circumstances of the particular case. Yes, Milord.
When it comes to the second category of cases relating to notional income of non-earning victims,
My lord.
it is my opinion that the above principles applies. Now,
Equal vigor, particularly with respect to homemakers.
that there also is this rationale is there about
Yes.
profession, whether it was permanent or not, etc., etc.
Lordship.
It is my opinion that the above principle applies with equal vigor, particularly with respect to homemakers.
Lordship.
Once notional income is determined, the effects of inflation would equally apply.
But once notional income, answer. Lordship.
I am asking you to dwell on the points that they are considering.
My lord.
Come to the component of just compensation.
Lordship.
It's not they have blocked their mind and simpliciter come to a particular amount. Further, no one would say that the improvements in skills that come with experience do not take place in the domain of work within the household.
Yes.
It is worth noting that although not extensively discussed, this court has been granting future. Let us.
We are not into that. We are not into that. Lordship.
So 41.1 is grant compensation on a pecuniary basis with respect to a homemaker is a settled property.
Agree? We are.
Taking into account the gendered nature of housework, with an overwhelming percentage of women being engaged in the same as compared to men, the fixing of notional income of a homemaker attains special significance.
Lordship.
It becomes the recognition of work, labor, and sacrifices, and a reflection of changing attitudes. It is also in furtherance of our nation's international law obligations, such and such. Various methods can be employed by the court to fix the national income of a homemaker, depending on the facts and circumstances.
My lord. Yes, case. Yes.
The court should ensure while choosing the method and fixing the notional income that the same is just in the facts and circumstances of the particular case. I would rather stress on this remaining part of the sentence. Neither assessing the compensation too conservatively nor too liberally.
Lordship.
Got it?
My lord. My lord, now I deal with this. My lord, the genesis, my lord, is the
I have
Milord.
time to deal with
Oh,
the
yeah.
rest.
Milord, I'll just indicate, Milord, one more thing.
Just-
Milord, after, Milord, first of all, Milord, I made one submission. Arun Kumar, on principle, with regard to 1/3, Milord, part of the income has not been.
Heard you, sir. I have heard you, sir. I have
Milord, second part.
what?
Every single case of Supreme Court wherein, Milord, the homemaker was, Milord, either has been decided on, Milord, the notional income of 3,000, 4,000, 5,000, 6,000, or on the basis of Minimum Wages Act. After taking note of Arun Kumar, including the most recent ones, Milord, I'll just give one to your lordship, Milord, 5,000 rupees considered. Rajendra Kumar's case, Arun Kumar taken note of and then said that, well, we will give 5,000, accident of 2012. Accident of 2012, and our accident is 2000.
No, the judgment is of
Judgment 2020, Milord.
Chief Justice
Chief Justice Gavai, Milord, when as Milord, his lordship was not the Chief Justice at that point of time. Justice Gavai and Justice Naveen Sinha.
subsequently, sir.
But Kirti takes note of Minimum Wages Act. That's what I say.
Paragraph 11.
Paragraph 11 and 14. I showed to your lordship.
11. 3 judges.
Milord, there is not even one judgment.
3 judges.
It's a 3 judges bench. होएगा जैसा को तो देखी है 11 and 14. 11 and 14.
Year 2025 Supreme
So I just read out that portion. I put a mark.
Milord, 11 and 14. Milord, 14 is the chart and 11 is, Milord, the assessment.
Minimum Wages Act was
Milord, 11.
11.
এটা তো খুলে গেছে কি করে তাড়াহুড়ো
read out where Delhi High Court had they had
But A there was no
Para 11, Milord. Minimum wages कहाँ गया?
right, next page है अच्छे. Next page है अच्छे. 10.
Milord, para 11, page number 177.
that I have seen.
Lordship, Milord, then.
That you are on the computation part.
Milord, the minimum wages. Your lordship asked in Kirti whether it is considered or not.
That I have.
Milord, perhaps I couldn't follow. Your lordship asked where the minimum wages has been shown. Paragraph 11, last line, Milord. Thus, at the very least, the minimum wages of rupees 6197 as applicable to the skilled worker during April 2014 in the state of Haryana ought to be applied in this case. Or, Milord, in the case of, Milord, the wife, Milord, it is 500 something, 5,000 something.
In Arun Kumar, this was kind of the approach adopted by different benches of to compute compensation by relying upon the minimum wages payable to a skilled worker.
It has been said to be a wrong precedent, which has been followed by all Supreme Court subsequently. What Arun Kumar says is illogical. Supreme Court follows that regularly. After taking note of Arun Kumar. Lordship. Yes, Rajendra Kumar. Milord, not only that, Milord, I'll go to the principal. Rajendra, Milord, yes. Rajendra Singh, Milord. Milord, Rajendra Singh, Milord, at one pattern noting Milord, Rajendra Kumar, Milord, paragraph 9, 10 and 11. এটা লুজ হয়ে যাচ্ছে এটা স্টেপল না না এটা স্টেপলার দিবেন Nine-minute deceased was a housewife of 30 years. Again, Lata Vadhwa comes in. Lata Vadhwa gives a maximum of 36,000 per annum. Then Arun Kumar dealt with. And then 11. The finding, Milord. The notional income of the first deceased is therefore held to be rupees 5,000 per month. আর কোনটা ছিল? Which one? হ্যাঁ। Wherever Arun Kumar has been followed, it has been followed for the quantum of 5,000 only. It has not been followed for the principle of 1/3 of the spouse's income. Nowhere. Even in 2023, that Sunita's case, Millard, 2025. Millard, I do not have the printout. Sunita's case, 2025. Sunita's case, Supreme Court follows Millard, the Arun Kumar and takes monthly income of 5,000. Again and again and again. 5,000, 5,000, 5,000. Judgment of how many judges? Sunita? Justice Sudhanshu Dhulia, Millard, is the writer of the judgment.
Which year? 2000?
Millard, 2025, Sunita's case. Cost settled ki bolo? Srimati Sunita versus Vinod Singh and others. 2025. Citation 2025, SCC online, SC, Millard. It is there in the tab, Millard, if my lord wants to have a look at this. 5,000 rupees, Millard, per month taken. Taking note of Arun Kumar. That yes, Arun Kumar said 5,000, so we are also giving 5,000. I accept that, Millard, that proposition. And Millard, one more thing, Millard, so Millard, Sunita dealt with Rajendra.
Was of the year 2010.
Yes.
So 5,000
Yes.
2010 in the year 2010 and 5,000 in the year 2025.
Millard, 2025, judgment of 2025, accident of 2003. Judgment of 2025, Sunita, accident of 2003. Arun Kumar accepted for 5,000 rupees.
What is what
Reference to the হাতে লিখে দিয়ে দিয়েছে এটা লিখে দিয়ে দাও না Milord, I'm just giving Milord this reference of Sunita. And Milord, I'll indicate Milord one more thing. I'll take Milord 5 minutes of my Lord's time, Milord. Milord, this principle was taken from the second schedule. Although Milord, the honorable judges in Arun Kumar said that well, we do not strictly follow second schedule because that is 163A, but still we take that principle of 1/3. Milord, second schedule is confined to the cases where the maximum income of the victim is rupees 40,000 only per annum. 40. 163 capital A. That is the schedule. In 163 capital A, Milord, the maximum income, Milord, it was had to be restricted to rupees 40,000. So, Milord, there, Milord, 1/3 of his spouse's income. Clause 6 at the bottom is written, Milord. In any event, it would never have exceeded 40,000 rupees per annum. The maximum benefit, what was envisaged under 163A, was 40,000 per annum. Rightly given, Milord. I don't dispute that 40,000 per annum becomes about 3,333 rupees per month. It was given. Even today, under 164, when rash and negligent driving is not to be proved, Milord, 5 lakh is maximum. 5 lakh maximum. Again, Milord, if we break into Milord in any normal death of a normal aged person, Milord, it would come back to 3,500 rupees per month. Even today in 2022, when that act has been amended. Milord, the parliament in its wisdom today in 2022, the act which is in force says when you do not prove rash and negligent driving, your monthly income would be taken to be 3,500, maybe 3,700. It is less than 4,000 by whichever way the calculation is done, taking note of multiplier. It is less than 4,000 rupees. Parliament says today. It is an act. Nobody challenges that. So, Milord, taking note of everything, when in 2022-23 Parliament says that you don't prove rash and negligent, we will consider the income, we will give you, Milord, this compensation on the basis of your income of less than 4,000. Lordship. And my lord, as far as my lord, the other judgments which were referred to therein in my lord's judgment, my lord, which was shown to your lordship, my lord, Hemraj. Hemraj, my lord, deals with only future prospect. It has got nothing to do, my lord, with the with this 1/3.
It was cited only to grant.
Lordship, my lord, one another bench, my lord, Justice Gupta's judgment was shown, my lord, wherein, my lord, which it was perhaps reflected to your lordship, my lord, it was told to your lordship that it had followed Arun Kumar. My lord, in that Justice Gupta's judgment, my lord, it is here with me.
I have not seen that. Let us.
My lord, income of 4,000 rupees considered. I'm sorry.
I'm asking you to give me that citation.
Down na, Josh Sahib ke. Para ka na, para 9, 10, 11. One stray judgment which is not followed anywhere.
This is the recent one.
This is the recent one, my lord. 19th March, koto tarikh? 19th March 25, my lord. Accident of 2003, of course. It takes note of, my lord,
Accident, the matter which we are dealing with,
2012 accident.
2012.
2013, 9th July 2013, my lord. I'm sorry. My lord, I can hand over a copy of the judgment, my lord, during the course of the day to my lord's office, if that is required. ठीक है, छोटा बार को रोके बोले दाओ, बार कोते लिए देते. My lord, so my lord, second, my lord, this new judgment takes note of Lata Wadhwa, Rajendra Kumar, my lord, Arun Kumar, all have been taken note of. Sunita's judgment. Tinta yache to. Tinta yache to.
And it's
It gives 5,000. My lord.
taken into consideration.
Lordship.
Because I'll tell you one thing. It has to be just
My lord.
comparison with the facts and circumstances of the
That's what your lordship. Yes.
and if it occurs that it is relevant to do so, then the minimum wages might be made applicable. If not, then depending on the facts and circumstances,
My lord, in the answer. Lordship.
the judgment.
Yes.
The Sunita's judgment.
Yes, which is deference. My lord, I do not have a copy. I'm sorry, my lord. Yes.
Go by that. Let me first read it.
Lordship. My lord, in the case which is in hand today before your lordship, my lord, in this case, my learned friend's case, my lord, learned tribunal judge, my lord, considered the monthly income of the deceased homemaker, my lord, 3,000 rupees.
He has come for enhancement.
He has come for enhancement. It is an admitted case that she was not working anywhere. She was a housewife. She was not earning. My lord, not like, my lord, this Arun Kumar, that she was working and she was earning 50,000 rupees. That was the evidence. So in this case, my lord, there is no evidence as such. My lord,
Sir, again, if you see,
Lordship.
she was earning, right? So then perhaps that concept was applicable or coming to the mind of
Judges.
The basic standard of living. So a person who was earning cannot be reduced.
My lord, I accept that. My lord, that is why. Yes.
Each and every case, it's to be dealt based on the facts of that particular case, or rather than getting it generalized.
My lord, the difficulty, my lord, what I face on this side, my lord, starting from Sallavarna, Pranay Sethi, all Supreme Court judgment says, my lord, that the income of the deceased is to be considered, my lord, on the date of his death. My lord, the cause of action, my lord, is the date of death. The entire principle goes down the drain, my lord. Everything goes down the drain. My lord, when a person is 59 years, my lord, 364 days old, my lord, his income Next day he's going to retire. He's not going to earn anything. Your lordship asks me to shut down and say that no, on the date of his death, maybe from tomorrow he will not earn anything. Admitted. But his income of 50,000 is to be taken into consideration. Why? Because today, on the date of accident, he is earning 50,000. Forget about what he's going to earn tomorrow. Tomorrow, admittedly, he's not going to earn. In this case, no, Milord, I'm on the principle. Milord, when in this particular case, or for that case, Milord, in other cases, for any reason, on the date of accident, admittedly, victim does not earn anything. Milord, I say you give him 5,000. I say you give him 6,000. Milord, no dispute on that, because that seems to be just. But Milord, if the person is going to get Milord 50,000 or 30,000 or for that matter any that amount, Milord, then Milord, the difficulty on my part arises, Milord. Then the entire principle that income on the date of accident, the cause of accident, Milord, is the date of accident, Milord, it goes, Milord, down the drain.
How many differential issues will be there
Milord, this lordship,
dealt with dissimilar manner?
Milord, I wouldn't have troubled your lordship, Milord, had Arun Kumar been followed even one case. There is not even one.
He did not get me.
Milord, I've got your lordship, Milord. Milord, how many dissimilar, Milord, these issues can be dealt with in one? I understand.
You didn't.
That is why it is inquisitorial. That is
Milord, my lord is in inquisitorial capacity. Your lordship, Milord, has to decide each and every case in its individual capacity, where what is just, Milord, what is realistic, what is proper. Milord, the facts are here before your lordship. Milord, my learned friend is relying upon one judgment which Supreme Court itself has discarded. And Milord, if stray judgments,
Copy of that Sunil.
yes, Milord. Milord, if stray judgments are to be dealt with, Milord, in 2025, Milord, last month only, one judgment has come up. Milord, just for the sake of Milord, I say 163 is to be followed strictly in terms of schedule. Forget about Unmila.
Certification also.
They did not even consider that. They say follow the schedule. 4,64,000 not granted. Milord, 2025, future prospect not granted.
Now,
Considering,
you understand why did I say?
Milord, that is yes, Milord, yes. Milord, if I intend to create trouble to your lordship, like my learned friends, what they are doing,
So saying I have
should not be thrown away to your lordship.
But there is no blood, external blood mode to determine the
Where is Mr. Joyanto Mondal?
lost blood.
Has he come to the yes,
একে বলো ক্যালকুলেশন না করে কে বাইরে ভেতরে আসে।
take tuition from him.
I'm extreme.
decisions also. and Udun Kumar Agarwal. This is from 2011, my lord, that 2010. That is the, my lord, one third, I think, my lord. One third of income of the husband.
I was right.
Yes. Yes.
As if all of
Click your Lord, he will stay back rather. He will not go home.
so then I'll
Yes.
ask
Hey,
the,
Krishanu আছে?
হ্যাঁ হ্যাঁ
Krishanu তো আসবি 16 তারিখে? বেঁচে থাকলে আসবে। Because he said if he survives.
on 16th.
these matters are there.
Tentatively,
Then I will ask the secretariat and please,
Milo.
they're having so many in the list.
Yes,
You-
for orders.
No,
Milord, your Lord
For
will be
orders.
taking up for orders matters or claim cases matters?
For orders.
for orders,
For orders, yes.
for orders,
Ah.
for orders.
Yes, my for orders. That will be my lord, disposal club.
Yes.
Then I will ask the secretariat to
Lordship. 16 আমাদের খোলা আছে গো 16 এ 16 এ
হ্যাঁ 16th
vacation bench
you have prior to that, everybody will get sufficient time to enjoy.
Lord Milord 16th is 16th vacation bench is there.
That's what I'm
Yes.
saying.
Yes, yes.
Vacation bench is there. You can hold a court. It's not that staff will not come, people won't be there. Your vacation. Matter. Tomorrow I intend to pronounce that judgment that you wrote.
Milord tomorrow your lordship will be taking up Milord
Any light matters. you
lordship. Milord tomorrow Milord we will not
Then happy Puja in advance.
I have one sir.
The call is appearing for the paper and appeal. On that day, I have filed last occasion. I have filed the paper. I have also annexed the cross objection. But as you mentioned, but it's not appearing the losses means the losses order that the cross objection number. Actually, not appearing the list. So basically, that the provision to add with the court of observation with the item number 216.
ওটা লিখে দাও না ওই তো ওখানে লিখে দাও কোড
Milord
নাম্বারটা
your
লিখে
lordship will
দাও
take up item 206 Milord on which day Milord after reopening?
If everything finalizes, I'll let you know by tomorrow.
Lordship.
about the 16th, they found. Then
No, my lord, this the last matter what my lord took, my lord, with Mr. Rahman.
On
Tomorrow, lordship.
Please,
adjourn for the day caller to
kindly direct manager check for tomorrow. Otherwise, I cannot do the matter for 16.
করে দিতেন হ্যাঁ ঠিক আছে 16 আসবো আপনার সাথে দেখা হবে হ্যাঁ
He doesn't understand, my lord. What?
No, it doesn't. That's Mr. Singh is correct.
Oh.
সুযোগ দিলেই ভুল বলতে
না ছেড়ে দাও
এই তুই ক্যালকুলেশনটা দিয়ে দিয়েছিস?
না
tomorrow you have a breakup party. Enjoy your breakup party. For liberal.
Item number?
আট নম্বর হচ্ছে 212
My lord, item 212 was taken up. We are giving the calculation to my lord's officer, my lord. Oh, bless your lordship. Extremely grateful to my lord.
Complete that by tomorrow.
Lordship.